Stop everything and pay attention, because what you are about to hear is not routine political news, and it is not partisan noise. What unfolded in the opening days of January 2026 has already begun reshaping the balance of power inside the United States, and the consequences will not wait politely for the next election cycle. If you miss the mechanics of what just happened, you will completely misunderstand what is coming next, not weeks from now, but days from now. The Supreme Court of the United States has issued a unanimous decision that does far more than target Donald Trump as an individual. It has ignited the exact constitutional stress test scholars have warned about for decades, but quietly assumed would never happen in real life, a moment where the judiciary, the executive, and the political machinery of the country collide at full force, without a release valve, without a compromise path, and without a clear exit. This is why understanding the structure of this moment matters more than reacting emotionally to it. In early January 2026, the court delivered a 9-0 ruling ordering the complete dissolution of the Trump Organization. Not fines, not penalties, not restrictions, total liquidation. Every property, every licensing agreement, every asset tied to the Trump brand ordered sold to satisfy judgments totaling hundreds of millions of dollars. Within minutes of the decision becoming public, financial markets reacted sharply. Trading related to Trump-linked entities was frozen. Major international banks circulated internal memos warning clients of legal and reputational exposure. Emergency briefings were convened inside the Treasury Department. This was not symbolic. This was systemic. The financial system did not simply observe the ruling. It responded to it in real time. The language of the court's opinion is what should have set off alarms across the political spectrum. The ruling describes conduct as persistent and systematic fraud carried out over multiple decades, designed to evade lawful oversight while exploiting institutional trust. That wording does not describe an accounting error. It does not describe aggressive business tactics. It describes an enterprise operating with intent, protected by corporate structure, and sustained by political influence. Yet while much of the media immediately fixated on Trump's wealth, Trump's reaction, and Trump's political future, they missed the real story unfolding beneath the surface. This ruling is not primarily about money. It is about legitimacy. It is about whether the American system still functions when someone powerful enough decides the rules do not apply to them. And that brings us to the most destabilizing detail of all. This decision was unanimous. 9 justices, appointed by 5 different presidents, representing decades of ideological division, a court that cannot agree on voting rights, abortion, executive authority, or even statutory punctuation, spoke with one voice. No dissents, no concurrences, no separate opinions, just a single ruling signed by all 9. And most damaging of all for Trump's defense narrative, the 3 justices he personally appointed all signed on without hesitation. These are not political enemies. These are conservative jurists with lifetime appointments who chose institutional credibility over personal loyalty. When judges with nothing to gain and nothing to fear make that choice, it signals one thing: the evidence left no room to maneuver. Now pause here, because this is where the situation stops being legal drama and starts becoming national risk. The Supreme Court exists as a check, not an enforcer. It declares the law, but it cannot execute it. Enforcement belongs to the executive branch, and when a former president publicly declares that a Supreme Court ruling is illegitimate and that he will not comply, the issue instantly transforms from a court case into a legitimacy crisis. Courts do not survive on force, they survive on acceptance. When acceptance breaks, authority fractures. In early January 2026, Donald Trump publicly rejected the ruling, declaring that the court had no authority over him or his property. Read that sentence carefully. This is not rhetorical outrage. This is defiance. In American history, this has happened only once before at the presidential level, and the consequences were catastrophic. When Andrew Jackson defied the Supreme Court in the 19th century, the court had no means to compel compliance. The result was not abstract constitutional theory. The result was forced removal, human suffering, and one of the darkest chapters in American history. The long-term damage was even worse. Once defiance proved possible, future crises escalated faster and broke deeper, ultimately contributing to national fracture decades later. But today's situation is more dangerous, not less. Trump does not command universal support. The country is already polarized. The Republican Party itself is splitting in real time. Internal polling circulating quietly in Washington shows a stark divide, with hardline supporters backing defiance and traditional conservatives recoiling from it. This is not a coalition. It is a fault line. And once that fault line opens, it does not close quietly. It widens under pressure. Let me ask you directly at this point, because your answer matters more than you might think. Do you believe Supreme Court rulings are binding only when they are politically convenient, or are they binding precisely when they are unpopular? Hold that question, because it will define how you interpret everything that follows. We are now witnessing 4 institutional crises unfolding at the same time, each amplifying the others and accelerating the overall instability. The first is the enforcement crisis, and it sits at the core of everything that follows. If Trump refuses to comply with the ruling, federal agencies are not left with discretion, they are left with obligation. That means the FBI. That means U.S. Marshals. That means court-authorized seizures of property, assets, and control mechanisms tied to the judgment. These are not symbolic actions. They are physical acts carried out by real people on the ground. And if supporters attempt to block, surround, or obstruct those actions, the federal government is forced into an impossible dilemma: enforce the law and risk confrontation, escalation, and potential violence involving American citizens, or hesitate and effectively concede that judicial authority ends where political resistance begins. There is no clean resolution available. Aggressive enforcement risks chaos and martyr narratives. Retreat or delay permanently weakens the credibility of the courts. Every possible response carries damage, and once enforcement is tested in public view, the outcome will redefine how much authority federal institutions truly possess. The second crisis is the internal fracture of the Republican Party itself, and it is unfolding faster than many outside Washington realize. Republican leadership is being driven toward a binary choice with no safe middle ground. Either defend Trump's defiance and, in doing so, signal that loyalty outweighs the rule of law, or uphold the Supreme Court and accept a potentially devastating rupture within their own base. Behind closed doors on Capitol Hill, quiet but urgent conversations are already taking place. Discussions about enforcement legislation, strategic distancing, messaging discipline, and sheer political survival. Lawmakers are weighing not only electoral consequences, but personal security, donor backlash, and long-term viability within a party that is increasingly divided into incompatible factions. Once a handful of prominent figures break ranks publicly, the dynamic changes instantly. What looks like isolated dissent becomes a cascade. The pressure builds, the silence shatters, and the dam does not crack slowly. It bursts, sending shockwaves through primaries, leadership structures, and the party's ability to function as a unified national force. Third is the international shockwave, and it is already in motion. America's allies are watching this unfold in real time, and they are recalibrating trust with the speed of institutions that have seen crises before and refuse to be caught unprepared again. Diplomatic statements released in early January 2026 have been cautious on the surface, heavy with formal language and careful phrasing, but their underlying message is unmistakable. Confidence in American institutional stability is no longer assumed as a baseline. Allies are no longer operating from certainty that Washington can reliably execute decisions, maintain internal coherence, or ensure continuity across branches of government. And when allies begin to doubt internal stability, adversaries do not wait. They probe, they escalate, they exploit hesitation, pressure rises abroad precisely because division deepens at home, because geopolitical competition is not driven by sympathy, it is driven by opportunity. The moment international actors sense that the United States is consumed by internal legitimacy conflict, they begin testing boundaries elsewhere, calculating that attention, resources, and political bandwidth are constrained. Fourth, and most dangerous, is electoral legitimacy, because it is the one crisis that can poison everything else at once. If a Supreme Court ruling can be rejected without consequence, the public is forced to ask the obvious next question. Why would an election result be treated differently? This is no longer theoretical debate or academic speculation. It is a logical progression that follows directly from the precedent being set in real time. Institutions function only when outcomes are accepted even by those who lose, even when the loss feels unjust, even when the outcome is politically painful. That acceptance is not a soft cultural preference, it is the load-bearing beam holding democratic process together. Once that norm collapses, democracy becomes performance rather than procedure, a contest of narratives rather than a system of rules. And when that happens, every future dispute is no longer resolved by ballots or courts, it is resolved by competing claims of legitimacy that can escalate into confrontation. Constitutional scholars and institutional analysts track warning indicators that signal whether the system is approaching a true breaking point. They look for compliance deadlines being missed, for shifts in law enforcement posture, for Congress signaling defiance or backing enforcement, for statements from senior military leadership implying concern about constitutional duty, and for state-level resistance that challenges federal authority. As of now, none of these indicators have fully triggered in the open, but the timeline is brutally short. Within days, not months, the Justice Department must decide how it will proceed, and every move will be read as a signal. Aggressive action signals institutional confidence but risks escalation. Hesitation signals fragility and invites further defiance. Even procedural choices, routine filings, scheduling requests, narrow statements can become strategic markers for whether the system intends to hold the line or quietly accommodate pressure. There is one scenario many insiders quietly hope for because it offers the illusion of stability: a negotiated compliance pathway that delays liquidation while allowing all parties to claim victory. In that scenario, Trump avoids explicit defiance while stretching timelines through legal maneuvering. Federal authorities avoid immediate confrontation. The court preserves face. The country avoids a headline-grabbing showdown. But this ruling appears deliberately constructed to prevent that escape route. The language, as presented, leaves no room for extensions, no room for alternative compliance structures, and no room for quiet modifications that would effectively turn a hard deadline into a soft suggestion. In other words, the court has forced a binary choice: comply or defy, with no middle ground that allows the conflict to dissolve into procedural fog. So here is the reality we face, and it is not comforting. If compliance occurs, institutions survive, but the political conflict intensifies as supporters frame enforcement as persecution and opponents frame resistance as lawlessness. If partial compliance occurs through quiet maneuvering and back-channel accommodations, institutions survive in the short term but weaken in the long term because precedent corrodes and the message becomes clear that power can negotiate consequences. And if defiance holds, if a Supreme Court order can be rejected in practice without decisive enforcement, the United States enters the most severe constitutional crisis since the 19th century, with legitimacy fractures that could radiate through elections, governance, and global credibility. None of these paths are easy. One of them is catastrophic. And now I want to hear from you. Not slogans, not party lines. Do you believe Trump will comply, negotiate, or openly defy? Do you believe the system still has the strength to enforce its own rules when power pushes back? And if the answer is no, what replaces it? Stay alert, stay engaged, because this story is not slowing down, it is accelerating, and what breaks next will not ask for permission.